an affirmative decision that was made by Congress to place them outside of protection. And that is the point at which the public has the right to copy and use it, that comes with entry into the public domain. That is the point at which Congress has said, we're done, we hit the limit, there's no more protection by definition. That's when I believe the limited time has expired, and that's the point that has to have permanent consequence. When Congress tells the public, we've hit the limit, this work is not under protection anymore, that's the point at which you have to have finality and permanent consequence, and I think that's what the limited times restriction requires, is a decision by Congress that marks the end of copyright that's going to be permanent.
So if we were talking about the idea of that Americans are presumed to know the law, might there be a better way for Congress to go about perhaps marking those works which have been copyrighted and are no longer copyrighted versus those works which were never copyrighted in the first place? Almost kind of like a retiree mark from the copyright market?
So I'm going to answer that because I have an interest in that. So I'm on the board of Creative Commons, and we have a way of marking things on the web, at least, that are under an open license. We also have a public domain mark. So if there is but the territorial piece actually makes it difficult because we currently don't have a mark for what I call the hybrid public domain. So U.S. government works that are in copyright, out of copyright in the United States, but potentially under copyright in a place like France. So we don't know how to mark those yet because we have to mark it at the machine-readable layer as well. But our public domain mark for anything, for Shakespeare, for anything that's in the public domain around the world, such a tool exists, and we invite you to use it.
Thank you.
Charlie Nesson, Harvard Law School. I've got a question for Tony and Michael. My take on the case was that the court is in search of a creation story. Where did it come from? I agree that the most profound question was Kennedy's, what is the public domain? And as I saw the case unfold, the key strategic decision that was made in arguing it had to do with the question whether the Congress created the public domain by its action in 1790, or whether the public domain is something bigger than something Congress created. It's something that predated the Constitution and was the state in which the collective sovereign citizenry that authored the Constitution. It was the environment in which it was authored, and therefore the environment within which we, the people, not only created the Congress, but authorized the Congress to create limited monopolies within the public domain. So